Now, in this act, these definitions may be a bit confusing. Ignore those definitions, but just understand. Zameen hai tatwavar, government prepared detailed lists of the persons cultivating land. Then absentee landlordism was prevalent at that time, and therefore they didn't have much attachment towards land. So government thought that if government gives power of ownership to the tenants, they will cultivate the land properly and they will also get justice. And some, after we got freedom, then socialistic attitude was more dominant. So from that angle, this act has been enacted as a land reform. Next, they are deemed tenant and protected tenant. Deemed tenant and protected tenant has these definitions, because earlier there was another Bombay Tenancy and Agricultural Lands Act, and definitions have been lifted from those acts. Here, tenant means a person who is cultivating land of another person by paying some khanda or hissa of that crop. Okay, and these definitions depend on the date of cultivation. Some are called as protected tenant and deemed tenant. Permanent tenant is also one more terminology, but they are tenants and they are eligible for getting that land to be purchased in their name. Okay, next. Now agriculturist. It is very interesting. If I say I am agriculturist, I am staying in Mumbai, I have never gone to my farm. But is it right? If I say myself I am agriculturist, is it right? Yes, I am right. Because here, what is the definition? Person who cultivates land personally. You will say that I am not personally cultivating land. But there is another definition in the act. To cultivate land personally means what? To cultivate land personally means cultivate the land through my relatives. Appointing labor is also cultivating land personally. Therefore, I can claim that I am agriculturist. And you know, in Maharashtra, only agriculturists can purchase agricultural land. Okay. Here, to cultivate personally by one's labor is also cultivating personally. And Tiller's Day is 1st April 1957. Means the person who was cultivating land on that day is deemed owner. Deemed tenant, but he is deemed owner. And there is some procedure prescribed under section 32G. He has to apply before Tahsildar, who is also declared as Agricultural Land Tribunal. And he has powers under Mamlatdar Court Act and powers of the Civil Court. Tiller's Day means Krushak Din, म्हणजेच 1/4/57. Government has declared in notification gazette that on that day, any tenant who is cultivating that land is a deemed owner of that land. Okay, they are. Oh yes, they are deemed purchasers, and these tenancy rights are inheritable. So, if that person even dies, his son, whosoever son or daughter, is eligible to purchase that land at a nominal value by filing 32G proceeding. 32G is a section under Tenancy Act which says that it is procedure for fixation of price. And what is the price that tenant has to pay to the owner? It is hardly, I think, 80 times to 200 times the 200 times the NA assessment. You know, NA assessment is not much, so it might come approximately about 500 or so. That means that land, huge land, he will get only for 500 rupees. For that matter, he will have to apply to the Tahsildar, that is ALT, Agricultural Land Tribunal, and he will hear both the parties, and then he will pass order that he is a deemed owner. And then after that, he will say that, are you paying that amount now or you want installment? He will give installments of that 500 rupees. And then a boja will be kept in other rights column till he clears the payment. When he clears that 500 rupees, then his name will be in occupants column and original owner's name will vanish. Next. Agricultural Land Tribunal. Yes. And after that proceeding is over, and after tenant pays all those installments of payment to the owner, then he is issued 32M certificate. It is single page certificate. It is the proof of conclusive ownership or purchase of that land. But since the tenant gets this land at a very, very meager price, there are certain restrictions on that land. He will get it in occupant class 2 capacity, and he has to take permission from SDO under section 43 of the Tenancy Act. There are certain conditions. Those conditions he has to fulfill. But now government has relaxed this criteria also, and whosoever after purchase, if 10 years have been passed, then just he has to pay the amount and he gets that condition of occupant class 2 removed. Next.
Any question on this?
This section 43 permission is given by SDO, and a person who is not an agriculturist, he cannot purchase land. But when a person is not an agriculturist but he want to purchase land, then there is section 63 in Tenancy Act that a person can obtain permission from the collector to be agriculturist, and on certain conditions collector can sanction that permission, but criteria are very stringent. That means I think 12,000 rupees annual income and landless labor etc., they get permission under that 63. And there is one amendment to section 63, that is 63 1A to the Tenancy Act. What it says, if you want to purchase land, agricultural land for industrial purpose, bona fide industrial purpose, then you need not be agriculturist up to 25 acres or 10 hectares. But if you want to purchase land more than that for special township project, you get permission from the government, that is minister, for purchasing more area than 25 acres and get agriculturist status. That power is with the government. Do you know what is special township? Anybody? If you have more than 100 acres, you have gathered more than 100 acres land, then there is a notification by Urban Development Department. You get lot many relaxations from the government. For example, stamp duty concession up to 50%, concession from Tenancy Act provisions. Even there are other relaxation like ceiling also. But what is important, you should have that letter of intent. Okay. And special township is not easy, because gathering 100 acres means more area than ceiling limit. You need permission for ceiling limit also for initial, because you will get relaxation after letter of intent. Okay. Then appeals and revision. Appeal against the order of ALT lies before collector. Collector's powers are delegated to SDO, and revisional power is with the MRT, Maharashtra Revenue Tribunal. Now here appeals and revision is with SDO and collector. One point I was thinking, I forgot, I'll just let on tell you. Tahsildar. Collector means SDO.
So collector's power is given to
SDO.
And then revisional power is with the
MRT.
Maharashtra Revenue Tribunal.
Correct.
It is Maharashtra Revenue.
One thing I recollected. See, there is one section 70B under Tenancy Act. It is very important section, in which landowner may seek declaration against tenant that he is not a tenant, and any person other than a tenant can seek declaration that I am a tenant to this land before ALT. That is section 70B. Therefore, I just told you, backdoor entry म्हणून आता बरेच जण 70B खाली मी tenant आहे म्हणून हे करण्यासाठी, see, my name is there in village form number 12 for succeedingly for more than 3 years. Now I am tenant of this land and I should be declared as a tenant under section 70B, and he declares tenant, he become agriculturist. So generally this is not accepted by revenue officers, but some have dared to do that. Then when without getting 43 permission you dispose land, and even you said कि without 32G he disposed, then there is a provision under section 43C of Tenancy Act. Anything done contrary to the provisions of the Tenancy Act, you are liable to get that land forfeited. And even if you have accepted that consideration, person who has accepted consideration, it is liable to be recovered as areas of land revenue by forfeiture, attachment and auction. Next. Now, I just introduce you to the Tenancy Act.